May I please, Your Lordship? I beg to mention item number 38, Your Lordship. Yesterday, I already submitted the adjournment slip for adjournment today.
What is the ground, madam?
Your Lordship, from the learned counsel, Mr. N.H. Bodavaya, due to personal difficulty, won't be able to
A
come.
prayer is made on behalf of Mr. N.H. Learned for the petition for an adjournment in the matter of personal convenience. Prayer is not objected to by the learned counsel for the response. Accordingly, registry to list this matter again after 2 weeks on the 3 weeks.
I beg to mention item number 36.
Huh?
I beg to mention, Lordship, item number 36 with the consent of the other party.
36.
Lordship.
Thirty?
6.
What do you want?
Lordship, kindly adjourn this matter because the council has some, senior council have some personal difficulties.
Jay Mullah.
Lordship.
Jay Mullah, Baki Akadiva. Yes. 3 weeks. Oh, no. Next week. 2014 matter, we'll take it next week.
Please, Lordship. Lordship, I beg to mention an affidavit in reply in item number 20. If the Lordship may allow to be brought into record.
Lordship, if I may, Lordship, well, they are mentioning it, but we have not received a copy. First of all,
Just give it.
If you don't, they don't.
how will it be
Mention
filed,
it. If
Lordship?
they don't get it, no, you don't get it, don't get it.
Furthermore, Lordship, this item was part heard and my lord had heard Mr. Bhuya on the last occasion. It was for the delivery of order.
Now,
They'll
if
give
he
a
wants to
copy, sir.
file, can I stop him from filing?
Lordship, I'm just,
Yes.
Oblige.
We'll see when it comes. Yes.
I beg to mention item number 15, madam.
Why?
They want to withdraw. Withdraw, madam.
Withdraw. Adoroni committee, huh?
Yes, ma'am.
Your name?
A. Mundal.
A. Mondal.
Yes.
Mr. A. Mondal, Learned Counsel for the petition on instruction submitted that the petitioner desires not to press the matter any further. So accordingly, he prays that he be permitted to withdraw the present petition. So prayer is not objected to by the Learned Counsel for the respondents. Accordingly, the present petition stands dismissed on withdrawal. Even if we give you 1 mark, you still not. Yes.
Yeah, Lordship, I beg to mention on read for listing in orders column, Lordship. Can it be on Friday, Lordship?
Please, Your Lordship. Lordship, in item number 28, we have filed an additional affidavit that may be brought on record. Deeply obliged, madam.
Nothing more is there. At 2 PM, we will deliver you. Yes.
My lord, before starting, Lord, we have committed a mistake. Lord, I am the in charge principal, my lord. The order by which I have been given the charge. That order, my lord, in
Okay, fine. That order now has been superseded by the order of
press appointment. My lord.
fresh appointment.
Yes, my lord. Now, my lord,
Yes, what is it?
My lord, another case was, my lord, filed by one Baharul Islam, my lord, challenging the
Challenging the same selection process.
not selection process, my lord, the appointment of
The
the
president.
president, my lord. However, court did not stay that proceeding, my lord. Only notice was issued, my lord. The same ground that
But now that I find that there is a communication that you are rethinking of changing the president. Yes,
so,
Mr.
my lord, my case, my lord, is that, my lord, I am the member secretary by virtue of, my lord, holding
No,
the
those
post
things
of, my lord.
we'll go into
No, my lord,
that.
these are
What
the-
is the incapacity or ineligibility of the respondent number 5?
No, incapacity and ineligibility, my lord, we are not questioning his incapacity or ineligibility. He should
Selection
be
was by the
committee which has not even been duly
Okay.
constituted.
We
in
will
accordance-
see.
My lord, my lord. So, my lord, as he has not been joined yet, my
No,
lord,
no interim.
my lord, no, my lord,
Selection we don't want.
my lord, I would not
It will
have
be
pressed,
subject to the outcome of.
my lord, I would not have pressed, my lord, only my limited.
Say, Mr.
Yeah.
Bhaiya, if there was some ineligibility on the part of the candidate,
My lord,
we would have immediately come in.
my lord.
Now here, the selection application and all were received by him, fine. Be that as it may. But the selection was made by a committee headed by the vice chancellor of the university.
My lord. That,
Thereafter, the director had an opportunity to go through that. So after those two seats, matter has come out and the appointment has been made, we will not interfere at this.
at this moment.
And your challenge, you have made a reference that some people have gone and made a challenge to the appointment of the the selection of the contingents of the president.
President.
There also no stay. So we will have it together. We'll finish it up. But Mr. A.R.V. Leonard, Senior Counsel, assisted by Mr. A.I. A. Ali, Learned Counsel for the petition. Also heard Mr. K. Gugul, Learned Standing Counsel, Higher Education Department, appearing, our Higher Education Department. The petitioner, by way of instituting the present writ petition, has assailed an order dated 21/8/2026 issued by the Director of Higher Education Assam, appointing the respondent number 5 as the principal of F.A. Ahmed College in pursuance to the selection process. Mr. Bhaiya has submitted that the selection process, that the very initiation of the selection process leading to the issuance of the order dated 21/8/2026 stood vitiated on account of the fact that the president of the governing body of the said college did not have the eligibility for continuing against the said post. So,
And my lord, another point, as a member secretary, my lord, I am the member secretary at that relevant period of time.
further,
My lord.
the petitioner, who as the in-charge principal of the college was also functioning as the member secretary, was not made a part of the selection process. However, Mr. Bhaiya fairly submits that there is no ineligibility alleged against the respondent number 5 to hold the post of principal of the said college. The said issues raised by the petitioner would require a deeper consideration. Also, issue notice returnable 4 weeks. Mr. K. Gogoi accepts notice on behalf of respondent number 1, 2, 3, 1, 2, and 3. Also, no formal notice. Petitioner to take steps for service of notice upon respondent number 4 and 5 by way of speed post. Also, steps within 2 working days from today. Also, it is provided that the selection and appointment of the respondent number 5 would be subject to the outcome of the present writ petition. Raised it to list this matter again after 4 weeks on a date.
Obliged, deeply obliged.
And you are making allegations against respondent number 5. You are not even made him a party by name, on his own capacity.
My lord, my lord. Let's check.
Your Lordship, Lordship need not look into the file because I have failed to establish any contact with the petitioner, madam.
You want to withdraw?
Dismiss for non-prosecution, madam. Withdraw will liberty, madam.
Well, pass orders on merit.
Madam.
We'll pass orders on merit.
Why should I increase my tally of my losing cases?
Lordship, pass.
Pass over go nalag. Withdraw go yes, exactly.
We'll dismiss it. But Mr. D. Goodwin, Learned Counsel for the petition. Also heard Mr. B. Chakraborty, Learned CGC appearing for the state respondents. The petitioner in the present proceedings has presented a challenge to the discharge ordered in his case from service on the ground that he was placed in low medical category. Goes up next. As projected in the writ petition, the petition herein was enrolled as a rifleman bracket general duty bracket over on 1/5/2003 in the Assam Rifles. Goes up. While the petitioner was so continuing in his services, in the annual medical examination carried out of the petitioner in the year 2015, the petitioner was deemed to be placed at a low medical category. Also, basing on the said position, it is projected in the writ petition that the petitioner was discharged from his services after his case for the purpose was recommended by the duly constituted board. The petitioner projects that the ground on which the petitioner was so discharged from his services, that is, being suffering from psychiatric ailments, being an alcohol dependent person, the medical board so constituted did not have a specialist in the field of psychiatry. Also, in the above premises, the petitioner has instituted the present writ petition assailing his order of discharge. Also, Mr. D. Gogoi, learned counsel for the petitioner, has reiterated the above facts and has submitted that the petitioners that the reason for discharge of the petitioner being so adjudged by a committee of doctors and there being no doctor from the specialty psychiatry, the said recommendations of the medical board stood vitiated and basing thereon the petitioner would not have been discharged from his services. Also, next, Mr. B. Chakraborty, learned CGC, appearing for the respondents, on the other hand, has submitted that the petitioner was invalidated out of service on medical grounds inasmuch as he was found to have been suffering from alcohol dependence syndrome. So, Mr. Chakraborty submits that the petitioner was initially referred to a psychiatrist in the composite hospital, in the composite hospital, CRPF Gauhati on 23/9/2014 and had undergone medical treatment therein. The petitioner at that stage was placed in medical category, low medical category -S3 bracketed T-24 with effect from 9/10/2014. Although the petition was counseled to abstain from alcohol consumption, the petitioner, after lapse of certain period of time, again resorted to consuming alcohol surreptitiously, which resulted in deterioration of his health condition, and accordingly he was admitted to the unit hospital on 1/5/2015. So, after the petitioner had received medical, he was referred to the Assam Rifles Composite Hospital, on 4/5/2015, he was diagnosed therein to be a case of relapse of alcohol dependence syndrome. So, accordingly, the petitioner was again recategorized to low medical category -S5. Also, the opinion of the psychiatrist of the Assam Rifles Composite Hospital, Sukhoi, was duly considered by the medical board as convened while an order dated 7/5/2015. Also, The said medical board having found the petitioner to be suffering from alcohol, to have again, to have found the petitioner, the condition of the petitioner to have a condition of the petitioner of being alcohol, of being a person with alcohol dependence syndrome to have relapsed, and such condition of the petitioner not being attributable and or aggravated by account of his service, comma. The petition was white order dated 22/6/2015. Discharged from his services on medical ground with effect from 1/10/2015. So accordingly, it is projected that the petition was so discharged from from his service with pension, with the entitled pension. Also, accordingly, it is submitted that the condition the petitioner was found in, comma, did not mandate his continuance in the post. Accordingly, it is submitted by Mr. Chakraborty that the order of discharge of the petition would not mandate an acceptance from this court. Also, this court finds that the facts noticed herein above leading to the discharge of the petition is not in dispute. The only ground raised by the learned counsel for the petitioner for the discharge of the petitioner from his services by the constituted medical board is to the effect that the said medical board was so constituted without a psychiatrist being made a part of the said board. Also, this said submission would not mandate an acceptance from this court in as much as from the materials that had come on record, more particularly from the affidavits filed by the respondents, comma, it is apparent that the medical board so constituted to examine the case of the petitioner had carried out the said examination also by appreciating the opinion rendered in the matter of the petitioner by a psychiatrist of the Assam Rifles Composite Hospital, Sukhovi. So the petitioner, by way of filing a reply to rejoinder to the said affidavit filed by the respondents, has not disputed the contentions and materials brought on record by the said affidavit. Accordingly, this court is of the considered view that the reason for invalidating the petitioner out of service on medical grounds being based on genuine grounds, comma, the petitioner's condition being such that he would have been a risk in the event he was continued in his services on account of psychiatric disorders suffered by him as a result of his consumption of alcohol and suffering from alcohol dependence syndrome, comma, this court basing on the materials coming on record is of the considered view that such discharge of the petitioner, comma, which was also by entitling him to his due pension and pensionary benefits, would not mandate an interference from this court. With and in view of the above conclusions, comma, the present petition is held to be devoid of any merit and the same accordingly stands. Let us give it a closure.
I am not this one. Obliged.
I would have come in because
I would
it's
have
called
contested.
Nana, neither attributable nor aggravated. It's called Nana.
No, I could have, my lords, contested because I have some citations, but the question, my lords.
What would be that is, you could have said, I would have required disability pension. But alcohol syndrome is not something attributable to the service. although you get it from the CSD
It
canteen,
was like, my lords,
it's
from
not attributable.
my
And
my
it's
case
not
was different.
aggravated. It is
This
per
case was
se
different, my
the
lords.
person.
I was not on an alcohol quality whatsoever, my lords. I am on the procedure. Rule 26 was not followed. That
But-
was my contention.
But here they have the opinion of the secretary and you have not disputed it by way of filing a.
My lords. All these minors, I didn't submit.
Hope the person is hell and healthy. Healthy.
Well, we can hope so, my lords, nothing else. Obliged, my lords.
Yes, Mr. Rao.
Sorry, my lord, on the last occasion I was absent.
You are here today. That is enough. Yes, what is your case?
That case, my lord, pursuant to an advertisement in the year 1996, I was selected and I was appointed in a school.
Now, where are the materials to demonstrate that you were continuing in this school?
Yes, I have annexed the, my lord, certificate in my reply also, petition and reply also.
Where, just take me to that.
My lord. Page 36. And in the reply affidavit also, the attendance register I have annexed. The only thing, my lord, when the appointment order was issued in 2010, well, the direction was the government decided to the persons whose names are appeared in the genuine select list. Director was directed to appoint them. And also, my lords,
Okay, where is the further certificate in the written statement in your reply?
my lord, in my reply affidavit, my lord,
You are working as on date.
yes. And in an inquiry, my lord, regarding my ADS salary, in an inquiry, my lord, the SDO civil submitted an inquiry to the deputy commissioner forwarded it to the government. In that, my lord, inquiry report, my lord, it was stated that the claim of,
Where do I get?
yes, my lord. Page 43, my lord, Annex 12. This inquiry was came out for, my lord, some irregularity starts from here, my lord. So
Where
all-
is your
all-
reference to you?
Not my reference, my lord. Kindly see, my lord, here, my lord, first, second, third paragraph. Page 43.
Regarding.
In the meantime, page 43, my lord, my petition. In the meantime, then DI Shri A.K. Tapadar passed an order almost on the same day, the High Court so and so, cancelling the earlier adjustment order of teachers from plan to non-plan without furnishing any reason thereof. Earlier adjustment order was passed by Mr. V.L. Job, DI of schools, right? So and so, in pursuance of the order of the Director of Elementary Education, Assam letter number so dated 1998, my lord. If kindly for a moment, kindly see, my lord, my appointment letter, my lord, page 31, my lord. Page 31.
Hmm.
Page 31, my lord. My lord, first paragraph, last sentence, my lord. This appointment was issued as per the DES letter number so dated 1998, my lord. And my lord, page 43, my lord, kindly see page 43, the inquiry report, the last mile finding, my lord. Page 44. Page 44. Bottom, my lord, last para, my lord. The adjustment order passed by the A.K. Tapadar, then DF schools whimsically shows that the adjustment were made against some posts where the teachers selected on 27/10/1999 and appointed on 20/11/1999. At main select list were the main results sheet were working. But in my opinion, Sri Tapadar has quoted some letter order as reference in his orders are irrelevant. He has done it is just to create confusion and further his own interest. Although I
So
cannot
you-
come to
To say that you are continuing in the services.
yes, my lord. And my lord, my lord, kindly see the annexure 14.
Now, where is the consequential appointment order after the decision of this court?
My lord, page 53, my lord, kindly see.
Ah.
Page 53, the decision of the government. My
So
lord.
those appointments have been done away with.
My lord.
Those appointments are gone. Where is the fresh appointment? No fresh appointment was made.
That's why I am before your lordship. My lord, kindly see the decision of the government, my lord. Page
Page
53.
54, we have seen, yes. Then
Yes, my lord, the decision, my lord. In view of the above, the Director of Elementary Assam is
Appoint.
directed to page 54, decision.
Hmm.
In view of the above, the Director of Elementary Education Assam is directed to appoint the persons in select list prepared in the meeting of sub-regional level advisory board Karimganj held on 27/10/1999 and authenticated by its chairmen. My lord, pursuant to this decision, my lord, the director issued three order, my lord, appointing 102 persons, my lord. And kindly see the first appointment, page 55. The government have speaking order to so and so resolve to appoint the person in the select list, sub-regional so and so was held on so and authorized by the chairman. The speaking order has been issued to
your names are not here.
no. And kindly see, the select list was also furnished to the director. Here is mentioned, my lord.
Okay,
And
fine.
in that select list, my name is there, my lord.
Okay.
It is admitted.
Okay, but their case before this court is that in the affidavit that they have filed,
Yes,
you come to the affidavit,
yes,
para 9, page 81.
yes. They have said the exercise which was they are saying, my lord, para 9, 8, 9, 10, that was those inquiry, my lord. After my lord decision, my lord, within 1 month, they have issued this appointment order.
Now tell me, you knew that others were appointed? 102 were appointed.
My lord, I am a handicapped person. I have been selected on the handicap quota, my lord.
What, cerebral palsy? Or what is your nature of your handicap?
My right hand, my lord, something, there was
That much
certificate, I
only?
have an
That much, but you have your senses and faculty all working properly. So tell me, when this exercise was being carried out in 2009, what did you do?
10. 10.
What did you do? In 9, what did you do? Where do I get material to satisfy myself? That you had also submitted due documents, everything, saying that, see, I'm working.
Yes, I have stated in my reply, that never inquiry was done in my school, my lord. No one, till date, no person has been appointed in my school, my lord. The appointment order issued, 3 order has been issued. In that school, no person has been appointed, my lord. In my
That
reply, my lord,
that you say that although they have made those projections, no
Yes.
such inquiry whether you are working or not was carried out by the authorities coming to your school. That is your stand in the
yes,
report.
and my lord, the anomaly, irregularity were done, my lord. The entire thing was inquiry in camp, my lord. My appointment where I have been appointed, my lord. In that school, no person was appointed by doing irregular appointment.
Lordship, paragraph 9, in our affidavit. Lordship,
Okay, what is the basis of this statement in paragraph 9? Records you say. What is the basis? How have you made this statement? What is the records which you have relied upon?
that as reported by the Deputy Inspector of School Karimganj,
Okay, where is that report?
that report is although not annexed here, Lordship,
Why?
but his name was there in the genuine list of 111. His name was of course there,
No issue.
but not
But
found
that you
working,
have not found working.
Lordship.
What
in
is the material to support that? Cannot be something on air.
Lordship?
Where is that?
Lordship may allow some time, I will.
No, this is
Because
matter
Lord-
of
here-
2000.
And
Here is
al-
only
and also,
affidavit.
Yeah.
And
Going
moreover,
means from today.
Lordship may kindly pay this
We are allowing the repetition.
paragraph 10 also.
You face the music.
Paragraph 10 also, Lordship. The entire exercise was over in the year 2010 as per appointment orders issued on so and so, so and so. And the petitioner has approached this court in the year 2016. Lordship.
No issue. Yes.
Only on the ground that he was not found working in the school, that is why.
What is the basis?
That Lordship allow 1 week's time, Lordship, I will produce.
Yes, Mr. Roy. Show me what steps you have taken from 1999 till filing of this case against the non-release of salaries too.
my lord, I have filed a representation, my lord, to
Where?
my lord, in my repetition, my lord. Annexure 10, page 38, then my lord,
10.
and
38.
annexure 10A,
Just. This is of no use.
and
2005 is of no use.
39,
Thereafter, after this exercise of 2009, order dated 19/8/2009, you were a party in the earlier writ petition.
no,
Where
But
is
my
the
lord-
order of this court? Order of this court earlier,
my lord,
5 writ appeal order. Not an
there are so many,
no, writ appeal order which led to this page 53 order.
that order is not here. But the
86 of 2008.
Okay, after this order of this writ appeal, when your appointments were all set aside, that appointment was set aside.
not separate, my lord,
By
by
the order of
order,
this-
subsequent order, my lord.
Oh, subsequent is a revival,
Re-
fresh appointment.
When, the moment when the order was.
Okay, you were not given a fresh appointment. What steps have you taken after 99?
Therefore-
After 2009.
Yes, therefore, my lord, I am before your election.
No. Where is that? You have not come in 2009, you have come in 2016.
Yes,
So this gap of 2009 to 2016, what were you? Where are the
my
materials?
lord,
to
being a handicapped person, my lord,
show?
I am
Handicap-
working there, my
a
lord.
handicap will not work out.
Well, work out, my lord.
You show me that how did you survive without salaries? What steps did you take from 2009 onwards?
That's why, my lord, I have been discriminated, my lord. My lord, kindly see, my lord, in my lord.
I
even-
want to know the steps that you have taken in view of the fact that you being a handicapped person, you are not being paid your salaries.
My lord, I have approached the authorities.
Where is that material?
I have stated in my
Where? Show me,
affidavit, my
show
lord.
me the statements.
But whenever I
Show
approach,
me the statements.
my lord, in my reply also, my lord, kindly.
Your statement is only vague. You have
No, my
not
lord.
set out any particulars.
My lord, paragraph 8 of my reply, my lord. Page 3. Paragraph 8 and 9. Whenever I approached, my lord, I was,
You have not said anything in your writ petition to that effect.
my lord, because
And
they,
you were in know-how of the appointments of 2009 affected in 2009. You have not denied that you did not know that fresh appointments were made in 2009. And you said that 2009 appointments were made, but I was not appointed. So from 2009 to
2010.
2016,
2010,
9, come to para
appointment order
Eight.
that appointment order are 2010.
Come to 2000,
Whatever. my lord.
para 8 of your writ petition. Para 8 of your writ petition. So this is the process after the writ appeal order, right? Now come to para 10.
Yes.
So this is an incident which took place in 2009, right?
Yes.
What did you do till 2016 before filing of the?
My lord. Kindly-
Where have you stated that your physical capability because of your prevented you from taking steps? Where have you stated?
Yes, this is my case, my lord, because being,
Mr. Roy, you're not getting my point.
yes,
2009, you knew that
yes,
your earlier appointments have gone. Fresh appointment was issued. You were discriminated. What steps did you take? I don't know, need you to come to Gauhati to file a writ petition. Where are your representations? Claiming that, give me this appointment, I'm there. You waited for 6 years.
my lord. All the, my lord, attendance sheet and the certificate of the.
That,
my lord,
that
headmaster.
continuance is no continuance in the IOP after the writ appeal is ordered.
My lord, but, my lord, may, if I can allow, my lord, may I submit another thing? The, it's admittedly my selection, my lord, whatever illegality had been done, my lord, in,
The council, your selection, your position therein, we are not disputing.
yes,
But 2009, there was a milestone. Things fructified in 2009. What did you do from 2009 to 2016 before instituting this? That much only.
my lord, in these circumstances, my lord,
Which circumstances?
my lord,
Lekha.
my lord, kindly, my lord, I have a right, my lord, for reasonable accommodation.
Mr. Council, you had a right in 2009, no issue. But after that, you don't have that right. That right got extinguished. Okay, let us come to your reply.
My lord, even they have not quoted, my lord, by order, my lord, Honorable High Court asked them to
Anything more?
my lord, how to place one judgment, my lord, reasonable accommodation, my lord. If, my lord, at this moment, my lord, if I am not provided with this reasonable accommodation, my lord, Lord, the concept reasonable accommodation, my lord, that is page 13, my lord. Paragraph 13, my lord. The timing is
Anything more? Anything more, Mr. Roy? Sharma, anything? Heard Mr. S.K. Roy, Learned Counsel for Education. Also heard Mr. P.N. Sharma, Learned Standing Counsel, Elementary Education Department. The petition, by way of executing the present writ petition, has prayed for a direction upon the respondent parties to issue, to release, to authorize to her current as well as areas salaries. Also, as projected in the writ petition, comma, the petitioner, who is a person with disability, who is a differently able person, had submitted a candidature in pursuance to an advertisement dated 28/12/1996 issued by the Director of Elementary Education, Assam, inviting applications for filling up of posts of assistant teacher available in various provincialized schools of the state, various lower primary schools of the state. So, it is projected that after the said selection process was concluded, the select list dated 27/10/1999 was published containing the names of 112 candidates. The name of the petitioner appeared at serial number 52 of the said list. Also, thereafter, further select list dated 13/11/1999 was so issued with 72 numbers of incumbents. Also, a further select list is also projected to have been published containing the thereafter it is projected that a combined select list was so published containing the names of 184 incumbents. Also, the petitioner has submitted that petitioner further projects that she was selected as against the quota mandated to be filled up by physically handicapped candidates. Also, the accordingly, it is projected by the petition that basing on a selection, she was white order dated 20/11/1999 issued by the Deputy Inspector of Schools, Karimganj, appointed as a stipendary teacher in, yes, which school? 482 Sheralipur Primary School. Against a vacancy occasioning on account of the adjustment affected in respect of occasioning on account of the adjustment made in case of one Meera Talwar against a senior plant teacher of 1242 Lakshmi Narayan LP School against a retirement vacancy of a vacancy occasioning in 397 Virgram LP School. What is this appointment? You are appointed in some school against a vacancy of some school which had arisen because of something. Lekha. The petitioner projects that she joined her services in pursuance to the said order of appointment on 1/12/1999. So, the matter pertaining to the publication of the three select lists, as well as the issue of which of the select list would be the genuine one, was required by a division bench of this court in the proceedings of WA Writ Appeal number 9/2007 and Writ Appeal number 111/2007 to be examined by the respondent authorities. Also, accordingly, the Commissioner and Secretary, Education Elementary Department, wide an order dated 19/8/2009 on an examination of the matter, proceeded to hold that the select list containing the names of 111 persons published on 27/10/1999 to be the only available reliable document to proceed with the processing of recruitment from the said list. Accordingly, the Director of Elementary Education Assam was directed to appoint persons from the said select list dated 27/10/1999. It is projected by the petitioner that her name duly figures in the said select list dated 27/10/1999. So thereafter, it is projected that the respondent of the Director of Elementary Education proceeded to issue orders appointing persons from the select list and accordingly in the year 2009 and accordingly 103 persons,
102.
102 persons came to
But
be.
they have said three, my lord, because
Okay,
don't know
102/103 persons came to be so appointed from the said select list. The petitioner was in the know-how of the fresh selection process being in a fresh process of appointment being initiated from the select list in question. However, the petitioner, as of 2009, is not found to have raised any remarks with regard to the exclusion of her name from the appointment orders, from the appointment orders issued in this connection by the Director of Elementary Education Assam, although the name of the petitioner figured in the select list from which such appointments were being so effective. Also, being aggrieved by the denial to her of her due salaries, both area as well as current, the petitioner has instituted the present petition. Mr. S.K. Roy, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that while the appointments were being effected from the select list in question by the Director of Elementary Education in the year 2009, no inquiry was made in the school wherein the petitioner was so serving as to whether the petitioner was continuing to discharge her duties therein. Mr. Roy submits that the name of the petitioner duly figuring in the select list dated 27/10/1999. It was the bounden duty of the Director of Elementary Education to also issue an order of appointment in the favor of the petitioner, inasmuch as they set the earlier appointments in terms of the directions passed by the division bench of this court were rendered non-est, and a fresh appointment process in terms of the merit position of the candidates obtaining in the said select list was initiated. So, Mr. Roy submits that the petitioner, having been admittedly been included in the select list by also reckoning her physical disability status, the Director of Elementary Education ought not to have ignored the merit position obtained by the petitioner in the select list and excluded her name from the order of appointment. Mr. Roy, by referring to the certificates brought on record issued by the head teacher of 482 number Sheralipur LP School, submits that the same would go to reveal that the petitioner, since the date of her initial appointment, effected by order dated 20/11/1999, had continued to render her services as a stipendary teacher therein. Mr. Roy reiterates that even as on date, the petitioner is continuing to discharge her duties in the said school. However, the petitioner has not been authorized her pay and allowances in the matter. Pay and allowances since the date of her initial appointment. So, per contra, Mr. P. N. Sharma.
Page 7 of my affidavit, my lord, I have also annexed another certificate of headmaster, 2017.
Mr. P. N. Sharma, learned counsel for the respondent, by referring to the affidavit filed in the matter by the Director of Elementary Education, has submitted that the petitioner, the name of the petitioner, although figuring in the list of 111 candidates, select list of published of 111 candidates, comma, when the process of effecting fresh appointments therefore was so done in the year 2009, comma, the petitioner here was not found to be working as a teacher in the school on the basis of her earlier order of appointment dated 2011-1999, and accordingly, her services were not regularized. He submits that in view of the said fact, he further submits that the petitioner submits that the exercise as carried out for effecting appointments after the directions were so passed by this court, by the division bench of this court, was concluded in the year 2009-10. And the petitioner had approached this court only in the after prolonged delay only in the year 2016, and accordingly, the petitioner would not be entitled any relief. Would not be entitled to the prayers and to the relief prayed for in the present petition. I have heard the learned counsel for the parties and also perused the materials available on the court. It is not disputed by the respondents that the name of the petitioner figured in the select list dated 27. The first select list date? 27-10-2019. So the petitioner admittedly was appointed in pursuance thereof, void an order dated 2011-1999. So, however, the said appointment effected in respect of the petitioner was only is found to be a tentative appointment, in as much as the issue as to which of the three select lists published in the matter was genuine was pending before this court. So, a division bench of this court in the proceedings of writ appeal number 9/2007 and writ appeal number 111/2007 had remanded back the matter to the government in the education elementary department with a direction to examine the matter and to decide as to which of the three select list would be is the genuine select list. Accordingly, while order dated 19/8/2009, the commissioner second, Mr. Relax. Mr. The secretary to the government of Assam Education Elementary Department, on verifying the three select list, had come to a conclusion that the select list of 111 persons as prepared in the meeting of the selection committee held on 27/10/1999 was the only reliable document to proceed with the processing of recruitment, for processing with the recruitment process. Accordingly, the Director of Elementary Education Assam was directed to appoint persons whose name figured in the set select list of 111 persons. A perusal of the order dated 19/8/2009 would go to reveal that the earlier recruitments made were held to be honest, and accordingly, the director was required to effect fresh appointments from the select list in terms of the order dated 19/8/2009. The director accordingly proceeded to issue appointment orders appointing persons in batches from the select list. Such orders were so issued in the year 2009-2010. However, the petitioner whose name duly figured in the said select list prepared in the meeting of the selection committee held on 27/10/1999 was not considered for such appointment, and her name was excluded from the process thereof. Next, the respondents have justified the exclusion, have sought to justify the exclusion of the petitioner from the select list only on the ground that the petitioner, after her initial appointment effected while the order dated 2011/1999 was not found to be serving in the school in question when the process for issuance of fresh appointment orders was being carried out in pursuance to the order dated 19/8/2009 passed by the Secretary to the Government of Assam, Education (Elementary) Department. Husam. This court has perused the said submission made, the contention raised by the respondents in the said affidavit. Husam. This court finds that the said contention to be clearly perverse, inasmuch as after the passing of the order dated 19/8/2009, the Director of Elementary Education Assam was required to effect appointments from the select list in question, and there was no stipulation made therein that such appointment would be made only in respect of persons who were continuing in their respective services in pursuance to the appointment orders issued in their cases in the year 1999. Accordingly, the ground assigned for denial to the petitioner of a due appointment in terms of a merit position in the select list in question is found by this court to be not acceptable. The petitioner in the present petition has brought on record materials to demonstrate that with effect from 2011/1999, the petitioner is continuing in her services, and the learned counsel for the petitioner has reiterated that the petitioner, even as on date, is continuing in her services. In view of the above conclusions reached by this court, the Director of Elementary Education Assam is directed to verify as to whether the petitioner continued to discharge her duties in the school in question to which she was appointed by the order dated 2011/1999. In the event the petitioner is found to have been continuing in her services with effect from 2011/1999 till today, the Director of Elementary Education would construe that the petitioner was also appointed, while it was so appointed in the year 2009, and thereafter proceed to compute the salaries receivable by the petitioner with effect from 22/12/2009 and release the same to the petitioner
1/12/1999. I joined.
1/12/1999 and release the same to the 2009. 22/12/2009 and release the same to the petitioner within a period of 4 months from the date of receipt of the receipt of a certified copy of this order. Also, the petitioner is directed to cooperate with the petitioner is directed to submit a representation along with a certified copy of this order before the Director of Elementary Education for facilitating the latter to comply with the directions passed herein.
But the second appointment, my lord,
2009 only we'll give you. We'll not give you from 99 because that has been gone. From 2009, when the others were appointed, you get it.
appointment may be issued, my lord, in
I have said you are construed. Deemed to be, what further I have appointed you.
Like,
Happy?
because they are,
You should be able to understand the mind of the court. Not the questions, the intention behind it. I just wanted some answers. That was, I was booking it. These cases, how can you? Their stand is perverse. But I wanted it from you. That's why. I got it from you. I started it.
God bless you.
In this case, my lord, two petitioners are there, my lord. One was retired, my lord, and one was appointed as a tutor. And that second petition filed in another writ petition, 152. So we met up taken on Monday along with them. Cannot, my lord. Because of that, that was in selling.
That, if you want, you withdraw it, go and file. Who asked you to file it? Who asked you to file it without, have you referred that this case is pending in that matter?
So, thereafter, my lord, after filing this,
Oh, that 2021,
my lord.
you have been appointed
No,
afresh.
no. Before my lord, that my lord, he was retired. Petition number one.
What? So that is gone. So his case is
No,
finished.
no, there, my lord.
Yeah, argue.
My lord, Monday, my lord. And second.
Petitioner number 2, you are not pressing this.
No, my lord, it is required, my lord, along with this WPC matter.
Mr. N. Bora, learned counsel for the petitioner, submits that the petitioner number 2. Have you disclosed this pendency of this matter in that petition?
No, before that, this was filed, and thereafter, this was filed, because of new order was there.
I know.
Or, mentioned, madam, mentioned.
Submits that the petitioner number 2 has filed a subsequent writ petition basing on the, has filed another writ petition basing on the subsequent developments taking place in the matter. This said writ petition was registered as WPC number
1583 of 2025.
1583 of
2025.
2025. Also, he praised that both the present writ petition be taken along with the said writ petition. Also, pray accepted. Registry to list the
Monday
matter
next month.
along with WPC number, what petition? On
31st November. Thursday or Monday, Tuesday,
on 10/9.
10/9, my. Nothing.
God bless.
Wait, please.
Yes, Mr. Wood.
Lordship, the matter pertains to non-payment of salary and arrear salary, it effect from August 2007. And it may be pointed out, Lordship, on last 6 occasions, the elementary education has taken time, last chance was given. And as per last order 29/1/26, it was sent for mediation, but
That
it has
failed.
failed, Lordship.
Okay, take me through the facts. This is elementary.
Lordship.
Hmm.
Lordship, the petition.
They don't have councils these days. Shortage of councils. Departmental councils. Okay, you make your assumptions.
Lordship, the petitioner was appointed as assistant teacher in Mingmang Badatipur LP School
Hmm.
in the year 1989.
Hmm.
And his service was regularized in the year 1992.
Just a moment. Assistant teacher in Mang. Huh.
And he
Then-
joined the school on 23rd/12/1989.
Hmm.
And thereafter his service was regularized on 1/6/1992. And Lordship may find that in page 16, annexure 3.
Then
And Lordship, on 3/2/2005,
And Lordship may find it in Annexure 5. His
Efficiency
payment
part.
efficiency part. And he has been receiving salary all in.
Then,
But,
then,
Lordship, then on till July 2007, he was receiving his salary. And the Accountant General has also issued the GPF.
hmm,
But Lordship, on 11/4/2013, the Director of Elementary Education served a so cause notice to the petitioner
hmm.
stating that his service was illegally, he was appointed illegal.
Hmm.
And to that effect, the petitioner has also filed a reply, which Lordship may find in page 24, Annexure 8.
Hmm.
And the authorities have also claimed that the petitioner was served with the termination order, but that has not been given to us. We have not received anything of that sort, Lordship. And Lordship, similarly situated persons have already approached this honorable court by writ petition 5635/2007, which was disposed of on 27/4/2012. And a writ appeal was filed by the department itself, but that was dismissed. Accordingly, the petitioners in the writ petition were being given the salary. And on the similar grounds, Lordship, another writ petition was filed, that is 1764/2008. And on the basis of the writ appeal, which was disposed or dismissed by the
What happened to the proceedings, departmental proceedings?
no communication was made to us, Lordship, after we have filed our reply. And when we approached the respondent authorities with the order of the honorable court for the other
cases.
file, but they have asked us to produce a order of this honorable court for the petitioner itself, and only they are going to process it.
That is the reason they wanted to help you. That is why they have not filed an affidavit in the matter. This is your case.
The fact.
Your case is that although they project that on 18/5/92, you were terminated from your services. This order was never communicated
Lordship.
and the DP has not been taken to its logical conclusion. You're still continuing in your service?
No, Lordship, I have retired
When?
2017 itself. Lordship.
Date?
I'm not exactly aware, Lordship, because the petitioner is bedridden right now, so I am unable to communicate with.
So on the date you filed this writ petition, you had retired.
No, I was in service. In the meantime, I was even transferred as headmaster in Adud Azhar Sapori LP School,
When?
Gauhati.
When?
Lordship, with 2/2/2000, 2nd February 2000. Until 8/1/2009, I was serving as a headmaster, but thereafter, one Ratneswar Mili had been appointed by this district elementary education.
Transferred to?
Lordship.
You were transferred to?
Adud Azhar Sapari LP School.
Is the order on record?
Order is not on record, Lordship, but I.
Statement?
Statement, number 9.
Para?
Para 9, Lordship. Page 6. After his appointment, Lordship, I was again serving as an assistant.
Yes.
Lordship, this is a 17 matter, my lord. Prayer has been made for, my lord, releasing the monthly salary as well as area salary with effect from August 2007. My lord, I have got received instructions of this matter, my lord. I've just pasted, my lord. Herein, my lord, this matter basically pertains to illegal, irregular teachers, my lord. And my lord, what has happened here is that
Illegal, irregular,
My lord,
both together or either one
the
of them.
petitioner here, my lord,
Is it illegal or irregular?
most probably illegal, my lord.
Most probably.
And my lord, here, my lord, what has happened is as per the instruction which I received, the petitioner was not approved by the government for accommodation as a teacher or tutor.
Why?
There was a scrutiny committee.
What happened to the departmental proceedings in Supreme?
My lord, there was a scrutiny committee which,
Forget the scrutiny committee, you have instituted a showcase, a departmental proceeding in this thing. What happened to that?
with that I have taken
That you,
instruction. my lord.
you don't have.
But my lord, just one thing,
Don't trouble yourself.
my lord, will just get the
Your
instructions. one-
department people are too busy to attend to court cases. So rest assured, we will take the need.
Lordship, just one.
And we are now
Lordship,
going to direct for the complete release of his salaries. And if he is found not to be eligible, the money will be paid to him. And all the officers who are there from that date, recovery from them.
Lordship, we'll just second part, Lordship, if I'm allowed to project my case, my lord.
Huh?
I'm allowed to project the case, my lord. My
But
lord,
give me materials to project that.
yes, my lord, I've given the.
This is nothing.
My
This
lord,
is rubbish. Trash.
my lord,
Show me the date of the recommendations. What happened to the departmental proceeding against you, against him?
and I have taken my
So
instruction.
forget it.
Because it's old, my lord,
2017
it is an
onwards.
old, it is an old
You
matter.
hear the order.
There were a change of guard, my
But
lord.
Mr. A. Bodua, learned counsel for the petitioner, also
But
heard
it's come
Mr.
after a
A.
long time.
Pukan,
The matter has come up.
learned counsel for the respondents. The petitioner in the present petition has prayed for a direction upon the respondent authorities for release of his monthly salaries, for his arrear as well, for his salaries, which are in arrears with effect from August 2007. So, at the outset, this court would highlight the manner in which the respondents have delayed the adjudication of the present proceedings. Notices in this matter was issued on 17/11/2017. So, thereafter, the matter was listed on 15/12/2017, and the respondents were directed to file their affidavit. So, the matter was thereafter listed on 29/1/2018, 21/2/2018, 14/3/2018, 9/4/2018, 3/10/2018, 24/1/2018, 31/1/2020, 18/10/2023, 21/12/2023, 10/6/2024, 17/2/2025, 17/2/2025. On all the said dates, barring, 14/3/2018, and 31/1/2020, the matter was adjourned on the prayer of the learned counsel for the respondents for time to file affidavits. So the present writ petition is pending since 2017, and till date, no affidavit has been filed in the matter. Accordingly, this court would proceed to consider the issues arising in the present writ petition by applying the principle of non-traverse. As projected in the writ petition, the petitioner was initially appointed as an assistant teacher in Ming Mang Badati Putara 27 LP School, wide and order dated 19/12/1989. The petitioner joined his services on, please have your seats, 23/12/1989. The petitioner further projects that his services were regularized by an order dated 1/6/1992. Whoso. The petitioner was also permitted to cross the efficiency bar, and also a GPF account was opened in his name. Accordingly, the petitioner projects that he was continuing in his services as a regular teacher without regular teacher. Also, however, the salaries of the petitioner was stopped from the month of July 2007. August 2007. Thereafter, the petitioner was issued with a show cause notice dated 11/4/2013. Also, was issued with a notice, show cause notice, requiring the petitioner to submit his explanation as to why his appointment shall not be treated as illegal and void ab initio on the ground that his services were terminated on 18/5/1992. The petitioner submitted his reply thereto on
Date has not been given, but it's
in the month of May 2013, and therein categorically denied of being served with any order dated 18/5/1992 terminating his services. The respondents are not found to have thereafter proceeded with the said process of determination as to whether the impugned termination order was served upon the petitioner or not. This court finds the petitioner further projects that while he was so continuing as an assistant teacher, the respondent authorities wide an order dated 5/2/2000 had also attached him services as the headmaster of Adur Azar Sapori Primary School for a particular period of time. The petitioner further projects that he continued in his services as an assistant teacher and had retired from his services in the year 2017. Also, the salaries of the petitioner not having been released, the petitioner has instituted the present writ petition. Also, Mr. A. Fukan, learned counsel for the petitioner, for the standing counsel elementary education department appearing for the respondents, has placed on record a communication dated, instruction dated 20/12/2023 issued by the Director of Elementary Education, Assam, wherein the only projection made was that all the documents relating to the matter was available with the government. The said instructions was available with the government. No further material has been brought on record. It was further contended that the petitioner was not approved by the government for accommodation. Other than Mr. Pukan submits that the above are the only instructions available within in the matter. I have heard the learned counsel for the parties and perused the materials available on record. The petitioner in the writ petition had clearly made categorical some contentions to the effect that after his initial appointment effected while the order dated 19/12/89, he had continued in his services regularly till the date of his superannuation. It was further projected that the services of the petitioner was never terminated, by also contending that no such order of termination was ever served upon him. So, the petitioner also has projected that in pursuance to a notice issued to him on 11/4/2013, the petitioner had submitted his reply thereto, and therein also had raised a categorical contention to the effect that no such termination order was imposed upon the petitioner. As noticed herein above, although repeated adjournments were taken in the matter by the respondents for filing an affidavit affidavits, no affidavit has been filed in the matter. The instructions placed before this court by the Director of Elementary Education Assam through Mr. A. Fukan, which has been furnished to this court. On perusal, this court finds that the only contention therein is that original documents related to the matter are available with the government. As is the common practice, the standing councils for the various departments not only represent the directorate, but also the government, concerned government, which in the case is the Department of School Education. It is not understood as to why the instructions requisite in the matter from the government was not permissible to be so issued to the learned standing council so as to place the same before this court. The conduct of the department in proceedings pending before this court leaves much to be wanted. So, the sole reason for pendency of the present writ petition is the inability of the respondents to place on record their stand in the matter promptly. So, they said feature which is now becoming a common aspect in most of the cases is not in the interest of dispensation of justice by this court. So, considering the this court leaves the matter at that. Considering the projections made in the present writ petition and there be no denial of the same, the contentions so made are held to be correct and not disputed. Accordingly, the respondent authorities are directed to compute the salaries receivable by the petitioner with effect from till August you got?
Till July I got.
From August 2007 till the date of his superannuation, and release the same to the petitioner within a period of 3 months from the date of receipt of a certified copy of this order. The area salaries receivable by the petitioner shall carry an interest of 6% with effect from the date the same was due for payment to the petition. The interest component now added to the area salaries of the petitioner shall be recovered by the government from the officials who were required to promptly place the stand of the respondents before this court in the present writ petition. So, the Commissioner and Secretary to the Government of Assam, the Commissioner and Secretary, Government of Department of School Education shall carry out an inquiry in this connection to identify the erring officials and thereafter pass orders for recovery of the interest component from such identified officers. With the above observations and directions, the present writ petition stands disposed of. Copy of the instructions furnished by Mr. A. Fukan is kept on record and marked as X for the purpose of hearing. Why should I, Mr. Fukan, blow out my head? This is the way more effective for me. You don't give me instructions.
Actually,
I will go.
wanted
What
to
is the
place one more
instruction? Mr. Fukan, what is the instruction there?
My lord,
Not accommodation. You say government. Government is some other thing in
my
North.
lord, one thing I wanted to show, one thing I wanted to show, my lord, that is that,
Going to,
And
I'll examine.
What
What is your stand? Tell me,
Now the matter is examining in the department.
Mister. You show, no, learn it. Standing Council Elementary,
Secondary education.
Secondary Education Department. The petitioners in the present writ petition has prayed for a direction upon the respondent authorities for authorizing to them pension and other pensionary benefits for the services rendered by them. Whoso. The petitioners in the writ petition have projected projected that they were initially appointed as assistant teachers in their respective high schools by the managing committee of the schools when the schools were in venture state. So, the schools wherein the petitioners were serving were subsequently considered and the employees found eligible, where services of the employees found eligible came to be provincialized. However, the services of the petitioners not being provincialized, they were treated as dropped teachers. Also, it is projected that in pursuance to the directions passed in the present proceedings with regard to drop teachers, any decision of this court denying them the pension.
Regarding here also, my lord.
I'm giving you an opportunity. Find out the decision. There is a decision. I'll not quote it. You will have to quote it.
But they are seeking pension from the venture state. They were appointed in a venture state.
They will get pension only from the date of provincial and Jivan Chandra Deka clause 6. Mr. Sharma,
Yes,
there is a decision.
yes, Jivan Chandra Deka also there.
Jivan Chandra Deka, forget, there is subsequent decision. You're not in a position to place it,
Right now I am not.
then we pass the rights. You give them pension. Leha. Pusa. In person, came to be provincialized, came to be regularized. Wide orders dated, wide issuance of orders dated. 21/6/2003 and 8/8/2003. Also, the petitioners have projected that although their services were so provincial, so regularized as drop teachers, the period of services rendered by the petitioners with effect from the initial provincialization of their respective schools, initial date of provincialization of their respective schools were not being considered for computing their pension and pensionary benefits. The petitioners in this connection had relied upon the decision of this court in the case of Jivan Chandra Deka and others, reported in Jiban Chandra Deka and others, order dated, judgment and order dated 1/9/2003 in civil villa number 157/1998. And the decision of a coordinate bench of this, and the decision of this court in the case of Dilip Kumar Medhi and others versus State of Assam and others, judge order dated 28/4/2015 in WPC number 3662/2009. Who's up? Mr. U. Sharma, Learned Counsel for the petition, has submitted that the matter pertaining to the claim of made by the petitioners in the present petition is presently being examined by the respondent authorities, and the said process has not been taken to its final conclusion. So, on hearing the Learned Counsel for the respondents and also on perusal the materials brought on record, this court finds that the services of the petitioners hearing were regularized with prospective effect while issuance of orders dated 21/6/2003 and 8/8/2000. 21 and 8/8/2003, 8/8/2003 and 2/8/2003. So, the regularization of the services of the petitioner having occasion before 1/2/2005, the petitioners would be placed within under the old pension scheme. So, further, applying the decision of this court in the case of Jiban Chandra Deka to the facts of the present case, the petitioners having been regularized by considering them to be drop features, the prescription made in clause 6 of the said decision to the effect that such appointments would be prospective in nature, but will carry the benefit of past services for the purpose of computation of pensionary benefits is found to be squarely applicable to the petitioners, case of the petitioners hearing. Also, accordingly, in view of the above position, this court directs the respondent authorities to compute the pension and pensionary benefit, to reckon the services rendered by the petitioners, past service rendered by the petitioners upon their prior to the regularization of their services for the purpose of computation of their pension and pensionary benefits under the provisions of the Assam Services Pension Rules 1969. So, accordingly, in the event the petitions have superannuated from their respective services, the respondents shall compute the pension and pensionary benefits of the petitioners by also reckoning the services rendered by them prior to the regularization effected in respect of each of the petitioners. With the above observations and directions, the present petition stands disposal.
But my lord, the appointment was prospective in nature, madam.
See, Jiban Chandra Deka,
And the other
it
was
is
past service.
prospective, but
No.
the period that they have rendered will be counted. Yes, next.
This issue is also same, similar to just, but here petitioner is initially appointed way back in 2019, 93. And since July 1994 to that June 2005, she was not getting the salary
You were initially appointed?
in 1993. The order is at page 13,
Page 13. 1-3.
139. Next,
Hmm.
this is the initial appointment order.
4 months.
Subsequently, whatever,
Where is the continuation? 4 months.
I've been appointed accordingly, I have been continuing in the post. Subsequently, Annexer V, page 15,
Hmm.
my services have been regularized.
Hmm.
My name is at serial number 25, that is page 16B. And accordingly, I was adjusted in a LP school and I've been continuing that. But here I'm aggrieved against the non-payment of salary since the July 94 to 2005. And accordingly, I opposed the learned Assam Administrative Tribunal, Gauhati. Annexer C is the order. Relevant portion is at all of page 27.
Hmm.
It was disposed of with the direction to the paragraph, last paragraph, madam. Fellows has got it. Page 27. Direction to the Director of Elementary Education as well as the Commissioner Secretary of Elementary Education to examine my grievance and pass in speaking order. That was intimated to the authority, but even after they failed to take up the matter, and it's remain as it is. That is why I approached the Honorable Court my presently, and approached my claiming the salary for that period, July 94 to 2005,
When
And-
did you approach the learned administrative tribunal?
2009, my lord. The
Nine.
order is at 12-10-2010.
Hmm.
10.
Hmm.
4-12-2010.
Okay.
So, my lord, in fact, my lord, in by way of this petition, another grievance is that while regularizing my service, here is a statement. Here is again come to page 15, the annexer,
2005.
that some that my services will be governed by the new pension scheme. But my compensation before
You were an
grievance is
excess
there.
appointee.
Malad.
You were an excess
Malad.
appointee, regularized by the cabinet member.
Malad. In fact, in similar circumstances,
Yes.
although it's those are Malad annexer Z, page 32,
Huh.
the judgment of that Swapna Talukar and another. This honorable court
Drop teachers. They
in
were drop teachers.
jobs, it's almost same. Malad.
Very,
I have
very
been
same.
continuing prior to
Yes,
that.
yes, yes. You had a service prior to this regularization.
Malad.
Yes, man.
Petitioner is excess teacher, my lord. Regard,
Ah,
this petitioner is excess teacher, my lord.
ah,
Regarding excess teacher, my lord, Punima Hore is there, my lord. This
where, where is Purnima? Para 102 and 108. Where?
18, my lord.
Place it. How can I know? I don't know.
Mapni, please.
Punima Hore was it?
Para 102, 108.
118, 4, my lord, specifically dealt with my lord excess teacher, my lord.
Para 102.
100. My lord.
Wait a minute. एकूण आहे पॅरा 102 प्लस आले तुमचं पूर्णिमा होते 6403-2021. So, Mr. Goswami,
Malad.
what do you say about Purnima Hore 102 and 108?
Malad, against that, Malad, you'll also stand in or judgment, that is order passed by the division bench.
That division bench only remanded back the matter, nothing.
Malad, sir, Malad.
6403-2020. Look at this. Only para 102 probably.
You'll also stand if there was the order passed by the division bench.
I know, I've seen, I'm aware of that. Doesn't help you. You are not even a party there. So you will be covered by Purnima Hore, 102 and.
Of course, I was not the repetitioner.
We will now make you a repetitioner.
Agree,
Mr.
appellate went
Goswami,
to
we will now
the
make
appellate
a re-
court.
we
The
will-
appellate court dispose of the matter with a
Whatever
rider.
happens
With
there.
a rider, if their service is not considered by the government, they can re-expose the appeal in the
You
appellate
also,
court.
we will now say
This-
that the decision of Purnima Hore will cover. You can go upon appeal and get that order, similar order. I can't pass that order. I'm bound by Purnima.
Well,
Okay,
in
we'll
view of
pass
the
the
appellate
orders after
court,
some time.
court order, you also may pass.
We'll discuss your petition saying that you will not have any bench. And your delay, 2005,
Well, regarding that area,
no, 2005,
Malo,
the order was passed.
No.
You approached this tribunal only into 4 years afterwards.
Malo,
4 years you accepted that.
no, not accepted. That is why I am a TISA. The financial constraints are there, Malo. Among the financial constraints,
Show
I
me a
approached the
decision.
tribunal.
Show me any decision supporting you on that.
Well, I approached the tribunal rightly remanded back to the authority.
could have gone back to the
They have
tribunal
not
with a
even
contempt
considered
petition.
it.
You could have gone back to the tribunal with a contempt petition. Why did you come before this court?
On
You have
my
not
part, there is
SLP.
no lapses.
That
That
is
is why
only-
I
Mr.
try to draw your attention, Malo.
Mr. Goswami, that is only an annexure now. Nothing more, nothing less. That order.
I cannot say it. I am a Tisha, poor Tisha, and the mighty state has disregarded the tribunal.
You were decide.
It's up to
You were
the,
decide for a long time.
and that is why I'm
Mr.
placed the
Goswami, you are-
actual
you
fact
were-
before your
Mr.
lord says.
Goswami, you were decide for a long time. You know.
Maybe Malot, once upon a time, definitely all
Okay.
are in that
Paisa?
side, Malot.
Page 102. Para 100. 102 pra 104 2. Heard Mr. U.K. Goswami, learned counsel for the petitioner. Also heard Ms. S. Chutias, learned counsel appearing for the respondents. The petitioner in the present petition has prayed for a direction upon the respondent authorities for has assailed has prayed for that. Petitioner by way of instituting the present petition has assailed the conditions as attached to an order dated 11/8/2025 by which the services of the petitioner was regularized against a vacant post. Next paragraph. As projected in the petition, the petitioner was initially appointed as an assistant teacher at Coral MKME School, wide and order dated 1910-1993. Such appointment was so effective for a period of 4 months. The petitioner projects that the appointment effected in her case was, however, continued with thereafter. The respondents, considering the petitioner to be an excess teacher, in pursuance to a decision arrived at in this connection by the cabinet, proceeded wide and order dated 11/8/2005 to regularize the services of the petitioner herein with prospective effect. On such regularization of the services of the petitioner with prospective effect, the petitioner was held to be only eligible for her regular salaries from the date of her joining in pursuance to the issuance of the said order dated 11/8/2005, and that she would be covered by the new pension scheme. The petitioner accepted the said order. Petitioner, in acceptance of the condition as set out in the order dated 11/8/2005, joined her services against the post. Joined the post against which her services were so regularized. The petitioner thereafter approached the Assam Administrative Tribunal by way of instituting an appeal, being appeal case number 3688/2009. The learned tribunal, wide judgment dated 4/12/2010, disposed of the said petition, said appeal case, by directing the respondent authorities to examine the claim of the petitioner for release of her area salaries. The area salaries of the petitioner are not being released, the petitioner has instituted the present petition. Mr. U.K. Goswami, learned counsel for the petition, by reiterating the facts noticed herein above, has submitted that the petitioner's services be continuous since the date of her initial appointment, which was so effected by order dated 19/10/1993, the petitioner would be entitled to count her would be entitled to record her services with effect from 19/10/1993, along with the regularized services rendered by her after issuance of the order dated 11/8/2005. Accordingly, Mr. Goswami submits that the petitioner being a petitioner having a service prior to 1/2/2005, the petitioner would be covered by the provisions of the Assam Services Pension over Rules 1969, and not the new pension scheme coming into effect with effect from 1/2/2005. Mr. Goswami further submits that the petitioner being in continuous service with effect from 19/10/93 and only in view of such continuous service, the petitioner being regularized in her services, while the order dated 11/8/2005, the petitioner would be entitled to draw her salaries in arrears after arrears prior to 11/8/2005. Per contra, Ms. S. Chutia, learned counsel for the petition, learned standing counsel, Elementary Education Department. Elementary Education Department, appearing for the respondents, have submitted that the issue arising in the present petition is covered by the decision of the coordinate bench of this court in the case of Punima Hore and others versus State of Assam and others, reported in judgment and order dated silo in WPC number 6403/2001. 2001. Also, accordingly, she submits that the present claim made by the petitioners in the present petition would not mandate an acceptance from us. Mr. Chaudhary, Mr. Bhattakur, what are you all waiting for? In the top of the list?
No, not in the top.
Then Mr. Chaudhary, come back at second up. I'll just finish up this 16 matter. Your is for that Gangadhar.
Item 14 is top of the list.
Okay. Then that we are reaching.
Yes.
So I've heard the learned counsel for the parties and peruse the materials available. It is an admitted position that the petitioner was initially appointed while an order dated 19/10/1993 for a period of 4 months against a post of assistant teacher. The services of the petitioner was thereafter continued with the petitioner being identified as an excess appointee, the case of the petitioner was placed before the cabinet. In terms of the cabinet, decision of the cabinet arrived at in the matter, the services of the petitioner was regularized while that order dated 11/8/2005. The said order, however, for the purpose of effecting the regularization of the services of the petitioner, had laid down a few conditions. One of the conditions laid down was to the effect that the petitioner would be entitled to a regular salary only from the date of joining her services in pursuance to the order dated 11/8/2005. Further, it was stipulated in the said order that the petitioner would be covered by the new pension scheme and not by the existing provisions of the Assam Services pension over rules 1962. The petitioner duly accepted the said a petitioner in acceptance of the regularization affected in her case joined her services against the post to which her services was now her services was now regularized, and accordingly the petitioner had accepted the conditions laid down in the said order dated 11/8/2008. The petitioner is found to have thereafter approached the Assam Administrative Tribunal after a lapse of around 4 years. The tribunal had remanded the matter back to the respondent authorities for examination of the claim of the petitioner. The same not having been done, the petitioner had instituted the present petition. Also, the issue arising in the present petition had also arisen in the proceedings before the proceedings in the case of Purnima Hore Supra. The coordinate bench of this court, after examining the matter in details with regard to the rights of the excess teachers to claim salaries for the period prior to regularization of their services, and also for regular reckoning the services so rendered by them prior to regularization of their services for the purpose of including them within the old pension scheme, had drawn the following conclusions. Para 1022 to 108. So this court has this court on perusal of the conclusions drawn by the coordinate bench of this court is in respectful agreement with the same. Also, accordingly, this court is of the considered view that the said conclusions squarely apply to the facts and circumstances arising in the present petition. Also, in view of the above conclusions, the claim made by the petition in the present petition not mandate and acceptance, and according the same stands dismissed in the light of the decision of this court in the case of the coordinate bench of this court in the case of Purnima Hore. So accordingly, the present petition is held to be devoid of any merit, and the same stands dismissed. However, there would be no A to A mathematics. Sorry, Mr. Swallow. In this matter, I want sometime I don't want to continue with the issue. Sorry, you move out, we will pass. We are not keeping it pending, not according to you. Your
I'll write.
convenience. We are dismissing the reflection. You say you don't want to argue, move out. 2018 matter, we are not going to keep.
So, Lordship, what happened in the meantime, Lordship, whereas so far as my learned friend is indicated, he absorbed in some other.
Who absorbed?
The petitioner.
Fine. You withdraw it, that's all.
No, Lordship,
Then you say you are not instructed, don't make submission. I'll pass my notice.
Lordship, that I have no instruction.
Mr. You doctor, Mr. You doctor, learned counsel. We'll say that you don't want to,
Yeah.
you're not me. You doctor, learned counsel for the petitioner also heard Mr. K.R. Patri, learned counsel appearing for the respondent number 6. None appears for the respondents number 1, 2, 3, 4, and 5. Mr. U. Doctor, learned counsel for the petitioner at the outset has submitted that he would not make any submissions in the matter in absence of instructions from his clients.
Yeah.
Accordingly, this court, the present writ petition has been instituted by the petitioner hearing assailing the selection and appointment of the respondent number 6 as assistant
Assistant.
professor in the Department of ASMIS in Uzoni, Mazuli, Calcutta College. Puso. As projected in the writ petition in pursuance to an advertisement dated 31/1/2016, comma, issued by the principal, Uzoni Mazuli Calcutta College, bracket hereinafter referred to as the college. College, comma, inviting applications for recruitment against a sanctioned post of assistant professor in the Department of ASMIS, comma, the petitioner, along with the respondent number 5 and others, had submitted their respective applications. Also, in pursuance to the selection process involved, comma, the selection committee had recommended the name of the respondent number 6. Also, such recommendation made by the selection committee was thereafter approved by the governing body, and the matter was forwarded to the Director of Higher Education for approval and issuance of necessary order of appointment. Also, the petitioner herein, having found anomalies with regard to the experience certificates produced by the petitioner herein, had approached this court by way of instituting a writ petition being WPC number 1671/2017, assailing the selection of the respondent number. Six hearing. This court, while order dated 22/3/2017, had disposed of the said writ petition by remanding the matter, by directing the Director of Higher Education Assam to take a final decision, being the appointing authority. Also, the Director of Higher Education Assam, in terms of the directions passed by this court, comma, proceeded by the speaking order dated 9/5/2017 to remand back the matter to the college authorities for a verification of the teaching experience certificate produced by the petition, by the respondent number 6, not 6. Also, accordingly, for the said purpose, the selection of the respondent number 6 was not approved with. Also, the matter thereafter was again placed before the selection committee, and the selection committee of the college again, on verification of the experience certificates produced by the respondent number 6, in its meeting held on 9/6/2007, proceeded to reiterate the recommendation made by it in favor of the respondent number 6 for appointment against the advertised post. Also, thereafter, the governing body of the college, in its meeting held on 21/6/2017, accepted the decision of the selection committee as arrived at in its meeting held on 9/6/2017. Thereafter, the matter being placed, the matter then being placed before the Director of Higher Education Assam, comma, the Director of Higher Education Assam, on a verification of the particulars of the respondent 6, proceeded while order dated 2/11/2017 to appoint the petitioner, the respondent number 6, as an assistant professor in the Department of ASMIS in terms of his selection for the purpose. Also, subpara, being aggrieved, the petitioner has instituted the present writ petition. Mr. K.R. Padgiri, learned counsel for the petitioner, has submitted that the projections made by the petitioner that the certificates produced by him with regard to his experience from JDSG College, Gauhati and Lakhimpur Kendriya Mahavidyalaya to be fake is clearly perverse inasmuch as the said certificates were so issued by the competent authorities of the said colleges, and the same had demonstrated that the petitioner had served therein as a lecturer, albeit in a temporary capacity. Mr. Padgiri has submitted that while the petitioner had made the said allegations, the petitioner has not brought on record any concrete material to demonstrate that the certificates, more particularly the certificate issued by the Lakhimpur Kendriya Mahavidyalaya, by the principal Lakhimpur Kendriya Mahavidyalaya, was a fake false one. He submits that the petitioner, while instituting the present writ petition, having raised a grievance with regard to the experience certificate issued by the principal Lakhimpur Kendriya Mahavidyalaya, had not implemented the said authority as a respondent in the present petition. So accordingly, he submits that basing on the said allegation leveled by the petitioner, the selection and appointment of the respondent number 6 would not mandate an interference from this court. I've heard the learned counsel for the parties and also the materials available. In terms of the selection held in pursuance to the advertisement dated 31/1/2016 for the post of lecturer in Assamese in the Department of Assamese of Ujuni Mazuli Calcutta College, it is found that the petitioner herein had secured (66.34 marks, while the respondent number 6 had secured 66.67 marks. The challenge to the selection of the respondent number 6 by the petitioner is found to be based on the fact on the ground that the petitioner did not have the requisite experience as a lecturer for being awarded marks in the set selection process under the heading experience. In this connection, the petitioner has raised a question with regard to the experience certificate issued to the petitioner by the principal Lakhimpur Kendriya Mahavidyalaya experience certificate dated 5/1/2010 issued by the principal Lakhimpur Kendriya Mahavidyalaya. Also, this court finds with regard to the content of the learned counsel, the petitioner had further projected the said certificate to be a fake forged one. This court finds that the said certificate of the petitioner, said certificate submitted by the respondent number 6, was duly considered by the selection committee in the initial selection held in its initial meeting held towards selecting the petitioner. Respondent number 6 against the post of a lecturer in the Department of Assamese, and the said certificate was again specifically considered by the selection committee in its subsequent meeting held on 9/6/2017. The said certificate on an examination was accepted by the said selection committee. Accordingly, the issue raised by the petitioner in the present writ petition of the said certificate being a fake forged one would not mandate a consideration by this court in an absence of any further cogent material brought on record to justify such allegation level by the petitioner against the petitioner in the matter. The petitioner further has not implemented the principal Lakhimpur Kendriya Mahavidyalaya as a party respondent in the present proceedings. The petitioner has only relied upon a RTI reply received from the authorities of Lakhimpur Kendriya Vidyalaya, Mahavidyalaya, wherein it was projected that records prior to 2000. Certain records were not available. The contention, the projections as made in the RTI reply by itself does not go to reveal that the certificate relied upon by the respondent number 6 issued by the principal of Lakhimpur Kendriya Mahavidyalaya to be opposed. In view of the above conclusions reached by this court, this court is of the considered view that the challenge presented by the petitioner herein to the selection and appointment of the respondent number 6 would not mandate an acceptance, and accordingly the same stands rejected. The writ petition next time is held to be devoid of any merit. However, no order as to dispose or dismissed. Okay, AR Tabilda, Learned Standing Council, higher education. Kata line liquidate. Mr. AR Tabilda, Learned Standing Council, KR Party has submitted that the respondent authorities had, that the selection committee had on the matter being remanded to it by the Director of Elementary Higher Education, examined the certificate produced by the petition by the respondent number 6 from the principal Lakhimpur Kendriya Vidyalaya, and on being satisfied that the same was so genuinely produced and the facts therein and the facts certified therein mandated an acceptance, had proceeded to reckon the said certificate and award marks to the petitioner under the column experience, also by treating the service rendered by the petitioner in Lakhimpur Kendriya.
All right.
So Sharma, have you got the instructions?
I have got,
The ban has got the payments.
so far, the, amount as regards to, retail benefits, the extent of pension, he has received the same. And so far, the PFM, he has also received the same.
All.
But only one aspect, he cannot clear as regards to, I'm simple, madam. Leave encashment, he could not, clear it, madam.
But that is already paid.
As per.
So nothing is surviving here.
Yes, madam, one point is like.
Yes, what is it?
Here in this matter, the petitioner is before lordship, that so far the appeal is concerned, that was not disposed of by the department in relation to the penalty imposed upon the. Basic relief was such. Because we have against the order of penalty, after the statutory appeal, that was not disposed of.
Okay. Now the pensionary benefits have been received,
Yes, madam.
but you are now assailing. But that appeal, merely non-disposal of the appeal will not do, you will have to assail the order itself. Have you assailed the order?
In this writ petition, I have not assailed.
Then,
Whatever, if you lordship, take note of our, my appeal, my lord.
no, the appeal is of 2017. Why should we now direct that?
2007, appeal was not preferred in the year 2017. Writ petition was filed in the year 2019, my lord.
But you have not challenged the proceedings here.
So for that part is concerned, we have already challenged in the earlier writ petition as regards to my lord, penalty imposed upon us.
But
This
that is
honorable
gone.
court has directed us to file the statutory appeal. Accordingly, we have preferred an appeal that was not disposed of. My lord. Basically, my lord, for penalty was.
Today, after 9 years, why should we dispose of, direct them to this? They will have nothing.
If the appeal is not disposed of, my lord, then another litigation will come as regards to challenging the impugned order, my lord, as regards to my panel.
That is for you. But if I have to say, I'll say that this is now attained finality. It cannot be.
So for that.
You think over it.
My lord.
Whether you want to press this writ petition or you want to withdraw it with liberty, you.
My-
What do you say?
Take some instruction from
On the prayer of Mr. M.K. Sharma, learned counsel for the petitioner, raised it to list this matter again on Thursday. Yes.
obliged.
No, 14. 14. 13, this is 13, Mr. Yes.
Lordship, file has misplaced somewhere at chamber, so 2 weeks' time may be granted. to Get back the file.
On the prayer of the learned counsel for the petitioner, raised it to list this matter again after 2 weeks on a date 2 weeks old. Yeah.
I do.
The only problem is no affidavit from anybody.
Mr. Chaudhary, you make your submissions, can't help it.
Yes.
We can't change the system.
Millard, my only case is Millard. Kindly come to the page 44.
Now you have retired.
I should have, but that instruction I don't have.
Since you have retired on
Should have
57. You are is it 62?
65 Millard.
65, okay, will be.
Yes. Possibly not.
Not.
Page 44 Millard, this is the report.
Hmm.
ICC.
Hmm.
Conclusion.
Hmm.
Based on 4 sessions during the period of inquiry by ICC, hearing session with the aggrieved woman and the respondent, independent testimonials of few individuals and hearings from 4 of the number of individuals mentioned in the complaint by the aggrieved woman, the following conclusions are hereby made. ICC concludes that respondents' acts and along with list of documents, names and addresses of the witnesses within this period of 10 days, inquiry has to be completed within so and so. Where are the procedure followed? Then
Yes,
Millard,
Mr.
kindly come to page number, last page Millard, 59, order of the appellate authority. I preferred an appeal. With reference to the above referred
Not
letter,
really.
it's so cryptic, Millard, nothing. I was not given any opportunity. I don't know what inquiry was conducted. As show cause was given, I submitted reply, that's all.
Yes. Who is appearing for respond number 6? You are appearing. Is this the finding only or is there is something more than this? Nothing more. What is this? What do you understand from this? What is the basis that the ICC, which, that's what I'm saying. How have you understood this? Because we'll also have to understand. Forget the petitioner, he has not understood. At least this court has to understand. Yes, sir.
Millard, Annexure 6
Just say here's one thing to say. Yes, yes. No. It's not that. When an ICC inquires into the matter, the rule 11 or rule 8, whatever it is, it says that it should be in accordance with the service rules of the
Yes.
persons concerned.
Okay.
No. That the recommendation has to be made after because now say in central government, that has been elevated to a level of an enquiry report. So if an enquiry report is without your, the cross-examination part, how will that be? No. That you come to rule 11, section 11.
It is there. Service rule applicable to the respondent.
So that service rule will take care of that aspect of the matter. It did not be prescribed here.
Oh.
And see, once you are, because this, again, an appeal is being preferred from that. It cannot be in air. There has to be some finding. Now, here there is no finding. Forget the cross-examination part. What are the allegations level?
How
And
the-
which of the allegations have
How
been
the
found to
conclusion
be-
was reached?
How? Yes,
My lord,
that we will think. Yes.
my lord, this annexure 6 is incomplete, my lord.
Eh?
My lord, without that an entire inquiry report, my lord, it has, this annexure 6 has been annexed, my lord.
Okay.
Kindly see, my lord, page 44 down below,
Hmm.
page 10,
Hmm.
and page 45 down below, page 11. You have that inquiry report, as per my instruction, my lord, it contains 13 pages.
13 pages.
But here, my lord, only 2 pages have been annexed.
How far is Gauhati University from here, Mr. Fukan? How much kilometers? 8, 9, 10 kilometers?
Only,
I'm sure it does not take 6 years for something to travel from there to here.
my lord.
Then, now you are taking up this big piece. Where are the material? Why have you not filed an affidavit here?
My lord.
Huh?
I'm
Otherwise,
sorry
it's
for
a
He may be
serious matter.
guilty. He may be guilty.
Yes.
We'll have to punish him. But if he is not, a senior professor is being made to suffer.
Yes.
Either way.
Yes.
If he is guilty, the lady should not suffer. She should get justice. But for your default, this matter is not being disposed of. So what do you say? We quash it. That's all. What
my
we
lord.
have material.
At least, my
We-
lord, 2 weeks time
non-traverse-
maybe, 2 weeks time maybe given
No,
to.
not
file
even a
the
day's
affidavit.
time. Not even a day's time. You explain why the affidavit was not filed and why these documents, your instruction was not placed before this court. We issued this notice in the matter.
Only 2 times, my lord, this case has come, but
Oh, I
that may
see.
not be, the
Okay.
ground, my lord.
From today onwards, the matter will be listed every day for 7 days.
That may not be the, my lord,
Oh, sorry.
my lord,
And there is an interim direction passed by this court in 11/11/20. If you were so serious to maintain this, because this is
my
something
lord,
which is your responsibility, so that ladies are there
my
safe.
lord, on that aspect, I tender my apology regarding.
No apology from
Lord.
Mr. Fukan is
Lord,
required.
regarding-
This is your authorities. So if you want me to adjourn the matter, we'll adjourn it subject to payment of a exemplary cost. Or we accept your submission that it was only listed twice. It should be listed at least for 7 times. We'll direct the registry to list it every day for the next 7 days.
Lord, I admit, my lord, that may not be the ground for, my lord, taking time to file affidavit. My lord,
But Mr. Ken
then
Chaudhary,
other-
Learned Senior Counsel, assisted by Mr. A. Hazarika,
No,
Learned
one
Counsel for the petitioner. Also heard Mr. PJ Saikia, Learned Standing
PJ
Counsel, Gauhati University, and Mr. PP Dr. Learned Counsel for the respondent number 6. Mr. Chaudhary had completed his arguments, and Mr. PJ Fukan, Learned Standing Counsel, Gauhati University has submitted that the findings of the inquiry, findings of the ICC as annexed as Annexure 7 to the writ petition is not complete. Such submission has been made by the Learned Standing Counsel, Gauhati University, purportedly on instructions. However, for the last around 6 years that the matter was pending before this court, the exact findings given by the report given by the ICC has not been placed on record by the Gauhati University authorities for reasons not known. However, considering the said submissions made by the Learned Standing Counsel GU, Gauhati University, registry to list this matter again on Thursday, on which date the Learned Standing Counsel shall produce the complete findings of the inquiry, findings of the report of the ICC, along with the action taken report thereon by the authorities of the government.
my lord, I'll be out of session from tomorrow, my lord.
Your
I
junior
see.
will produce it.
My lord, I have got that inquiry report right at this moment, my lord. But I'm on another aspect, my lord. This appeal, my lord.
Annexer, you will let us get over the inquiry report first. What is that? Show me. If you had that, you should have pressed it before me. The complete copy. Why do you wait for me to pass an order?
And that appeal should have been filed within 1 month. And that too before the executive authority, that means the executive council, but it has been filed before the vice chancellor.
Mr. PJ Fuka to produce the original copy of the inquiry report submitted by the internal complaints committee on the next day of this week. Raised it to list this matter again on Thursday. Mr. Chaudhary,
Miller.
I think they have done a blunder in not giving you the whole copy. But still, I don't suppose that there is something.
Yes, yes.
Let us have the originals
Can it be
on
on,
Thursday.
can it be on 8th or 9th, Milord? That will be better for me.
I'll forget.
Milord,
You're going out somewhere.
yes, some, Milord, very important, Milord.
What do you
Family,
say, Mr.? On 8/9.
on 9th, Milord.
9/9. You produce that original and you give a copy of this, if possible, to Mr. Chaudhary and Mr. Dr. Hong.
I'll also have to ask my instructing council.
But I don't think so. They have
That's
given
right.
you this.
If-
And I still think something is missing there. Go through them.
Procedure part would definitely some flaw is there.
Boys,
Most
If-
of them.
how is your case covered by the Supreme Court decision?
Well, they have the same qualification, we have the same qualification.
Only that much.
And we were also, my lord, recommended by the
Yes,
district
produce it.
disciplinary committee.
In Supreme Court case, Lordship, whatever the issue on the was the deemed confirmation.
Here also,
Here
part
also,
B,
no, Lordship.
part
The
B,
issue,
they had submitted
No.
part B that was accepted.
our contention in respect of this case is that they are not qualified as per prescribed qualification.
No, those people are also not
Yes,
qualified. They
Bhatkal-
also Bhatkal.
But in that case, Lordship, that issue was not before the Supreme Court on that
Oh,
qualification. But that was a.
Why wasn't it taken up, my lord? It was no.
prevented you from taking. Mr. Goswami, he's already in a soup. Don't put him into more trouble. Yes.
Lordship, in that case, Lordship, Mohardin Sheikh case is also under review, Lordship, before decision of the court. That decision is not yet
They are
final.
concerned with music teachers.
In the Nur Islam
Islam.
case, when the Nur Islam case was placed before the honorable court, that review, that department has filed review was not also placed before this court, for which that government has filed already the review petition
We are not concerned.
against the Nur Islam case.
Once the issue has been decided by the Supreme Court, how will a review petition on that point be maintained?
But-
Doctrine of merger.
Doctrine of Mada would come into play if Lordship in
Putni Mohammed.
Nur Islam was not specifically dealt with the qualification issue, but it
That's
was
right.
come as a collateral manner, Lordship. So I'll satisfy.
Obstructive breath.
I'll satisfy on that point, Lordship, by bringing those, Lordship. One day law, I am paying on that. Because when the review is also pending before this court, again,
You
Mohar-
Not accept.
For further hearing.
Yes, but I hear. Good afternoon.
On the, Mr. PP, Dr. Learned Counsel for the, heard Mr. B.D. Gusam, Learned Counsel for the petitioner, Mr. PP, Dr. Learned Standing Counsel, Secondary Education Department, Secondary, submits that he be granted time till 10/9/2026 to submit, to make his submissions in the pre-accepted, registered to list this matter in 10/9/2026. That's it. If it comes back to me, I'll do it. Okay. Top of the list. A 17, 18 to Matina, 19, 20, 21, 22. It means what I did. Sir, we'll have it in the first of the next.